afternoon. Thank you very much for joining me today. It's a great pleasure to have you here.
It is really a pleasure of mine for your invitation to be with you and enter into a conversation. Hopefully, that would be interesting.
I'm sure it will be, sir. Thank you very much indeed. Sir, may I perhaps try and ask you about your background, your upbringing, and where you originally kind of started your early years of life?
I am born and brought up in Hyderabad. It is Telangana today. It was Andhra Pradesh yesterday. But otherwise, I'm born and brought up in Hyderabad. I did my schooling, I did my college, I was in employment. All these things happened in Hyderabad, by and large, till the age of, say, 35. When I said schooling, I started with a sentence school, which is in Secunderabad. Thereafter, it was co-education. So I was put in a Mehboob College, which is also in Secunderabad, where I started studying from the class 4. I passed out in the year 1970 in this college, which is actually a school. And thereafter, I joined Nizam's College, where I did my Bachelor of Arts, which is called BA. My subjects were mainly economics and public administration. Thereafter, this was between 1971 to 74, and I joined the Arts College in the Usmania University campus. I did my master's in economics, MA economics. After passing out, it was what do you call it? Quite a lull period where I did not know what to do. Thereafter, I did not get employment. I did not get a big government job which people generally aim to get. And after spending for some time, I got into employment where I was appointed as a senior accountant in the government of the then government of Andhra Pradesh, where I spent some time. During the course of my employment with the government, I happened to do my law. Although I started, as I told you, a lull period where I actually took admission in law. After taking admission into law, I got employment. After getting into employment, uh, I had to discontinue with law. Thereafter, there was a provision to do law in the evening. I got myself readmitted and transferred to the evening college and completed my law successfully around the year 1985.
Must be a long gap.
Yes.
Right. And then how many years it took you to finish the law?
I told you the law was between 1981 and 85.
Right.
The college education actually stopped in the year 1976. Between 1976 and 81, it was a lull period where nothing much happened.
Right.
Excepting being like a supervisor roads and buildings, as I always say, which means I did nothing. Just spent time, whiling away time, trying to figure out what can happen, what should I do in life. So, I mean, for me, it looks like, and again, it may be coming from my own background, things which I saw. So, it looks like that you perhaps had a family background where education was given quite good importance and education was important for you. So, did you not receive any guidance during that lull period or kind of like exploration you were looking at? See, my father always insisted I can't give any kind of property to my children. The only property which I can give to my children is educate them well. Because my father comes from a small, humble village background family in Tamil Nadu. And then he came and settled down in Hyderabad. Me and my brothers and sisters were all born in Hyderabad. So I don't say my father was in a position to advise me as to what I should do in life, excepting teaching. that I should always speak the truth. Come what may, face life, and truth will support you. This is the ideal message my father gave. Carried that throughout my life so far.
Was your father a lawyer as well?
No.
See.
Father was a very simple and humble background person. He was not educated in that sense. All his education was informal. He started learning by doing things, and he was part of a company, a private company. He was representing the company in promoting the sales of the company's. That's the background from where my father comes.
And then what made you to move to Delhi currently you are now?
While I was in employment, some of our colleagues in the department, they were having a problem with their service promotion. And they told me, since you have done law, why don't you pursue our case? That brought me to Delhi before joining the profession. That particular case brought me to Delhi, where I pursued their case, of course, unsuccessfully, before the Supreme Court in the year 1987. After going back, I started thinking, what life will give me when I'm continuing in this employment? Can I not be better off doing something which is more challenging in life by entering the profession? That process kept me thinking for almost a year. Thereafter, I decided, call it a day as far as this employment is concerned, against the wishes of my friends and then well-wishers and family. I resigned the job, joined the profession in the year 1988. When I said I joined the profession, I became a member of the Bar Council of Andhra Pradesh, then Andhra Pradesh, and I started my practice at the High Court of Andhra Pradesh at Hyderabad. That was during the beginning of 1988. After spending for more than 4 years in Hyderabad, then I thought, I remember the days when I came to Delhi, pursue the case of my friends, colleagues in the office. That kept me or kept my thinking alive. Ultimately, that led to my taking a call again, jumping from Hyderabad to Delhi to be at the Supreme Court. So I began my career in the Supreme Court as a lawyer from the beginning of 1992, but otherwise I stepped into Supreme Court in the year 1991 itself.
Right.
But settled down in Delhi from the beginning of 1992.
Did you find it difficult to settle in Delhi? Because coming from, let's say,
Initial days was really challenging in the sense not only changing the career, but also changing the place. Geographically, it's a different entity. Everything is different in Delhi as it was in Hyderabad. So it was challenging in that sense. Hyderabad is the relatively better place to live as compared to Delhi. Most interesting and challenging aspect was in Delhi was Hyderabad was a mini. When I came to Delhi, it was actually mini India. It's a great confluence of people from all walks of life, from all parts of India, Delhi as such. More particularly, when it comes to Supreme Court, you have a lawyer from every part of India leading their lives in Delhi. So, at one place throughout the year, you get to meet, interact, make friends from people from all, what you call it, all over India. So that's the great benefit where from being a frog in the well, you're out in the ocean where you get to meet so many people from across the country. So that is the richness which will give you a broad horizon in thinking, and that will keep you in a good stead as far as understanding the society and the world at large.
That's a great way to put it. So in Supreme Court, how did you manage to make your inroads? I mean, you coming from a different part of the country. Also, I'm supposing now, did you have some friends over there or any, associates or contacts? How did you establish yourself?
I first made myself Delhi.
Right.
And slowly and steadily got into friends, picking up one after the other. It happened in a natural course. I did not choose anything. I did not think in terms of who should be my friends. It happened in a very, very natural way. Whoever we came across at the initial stage, 1992 onwards, are still my friends. It is not as if I meet you today, tomorrow I forget you and then think of somebody else. So, whoever I met in the initial period, even today I interact with them and I have a good relationship, all of them.
So the friendship led to professional development. Is that the way you want to put it?
Correct. Initially, it was, as I told you, when people are yet to understand you in Hyderabad as a lawyer. Although I was there for more than 4 years, I met number of persons, made number of friends, acquaintances, etc., etc. But it was not enough think in terms of who you would support me in Delhi. But slowly that happened. What I always believe and experienced is with a large heart and with an open mind, if you are pursuing something genuinely, the nature has got its own way of dealing with you. It will unfold in such a way that it will only give you something which is positive. I more than I believed it, I did that and I experienced it.
So you had no strategy as per se that how and which way you'd establish yourself. You basically were following the natural course.
It was only I left it to the nature. As nature unfolded, it only benefited me. I might not have grown up as a big lawyer in Supreme Court or generally speaking as a big lawyer, but by being in the legal fraternity, I got to meet and interact with all kinds of lawyers from the bottom to the top. I got to interact with a good, what do you call it, lawyers who have made good inroads into the profession. They became judges, etc., etc. So that's the advantage which I had. Because of my nature, trying to meet people, not only connect with people, but build relationship. That kept me in good stead. And what all is a consequence of this.
It's very nice. So you think building relationships is important for anybody's professional or even personal development?
It is always good relationship. Not only connecting with people, but also building good relationship. That not only keeps you in good stead, but that will take you a long way. See, there are two things. One, you can be a serious lawyer, not connected to anybody, right? Connections in a very, very limited way, totally concentrated on the profession, reading, writing, and speaking, right? Always do that, and you can grow as a lawyer. At the same time, you can also do the other thing, where you connect with people, build relationship, and also be in the profession. I did the second part, the first one.
And did you come across with any barriers, or was like relationship were developed as such that you managed to cross all the barriers? And if
As I told you, barriers are going to be in a very natural way. If barriers occupy your mind, then what happens? Those barriers will be such it will look like a mountain, and for you it is difficult to cross. But if you in your mind think that is non-existent, then in a natural way, your barriers will not hold you up. Example, in a profession of law, in the lowest court of the hierarchy, you get to know the client easily. You can develop yourself in such a way where you get to draft petitions. You stand up before the court. Although you falter, nobody questions you. You learn. And in the process, build in your profession. When you come to the High Court, this particular limitation which you saw at the beginning will be non-existent. You will be better off, but the opportunities are relatively very less. When you come to Supreme Court, to develop your skill as a very good arguing lawyer is very limited because we operate in Supreme Court mostly under the Article 136 of the Constitution of India, where the scope is limited. The court will interfere with the judgment of the High Court when you are standing before the court and then trying to point out where lies the mistake as far as the High Court judgment is concerned. The scope is very limited. And then the court has got its own discretion whether to allow your plea or dismiss your plea. Whereas when you stand before the High Court, Article 226, you have very wide scope. Try and convince the court. You will be allowed the time you want to take with your arguments. Prevail upon the court to what you will interfere with, whatever your plea is. That becomes very, very limited when you come to the Supreme Court. So these are all barriers in a way. If you take it seriously, you can't overcome it. If you ignore that, start working on this, then in a very natural course, you overcome all this.
So what kind of prep you do? What would you do? Do you do just research, look into the case laws? How would you, because these supposed to be convincing or conversating with the judges. You're trying to get into a very narrow passage, if I may say so. So what were your preparatory things?
Any and every lawyer should be thorough with his facts. Factual basis of your case is important for you to build and convince this judge with the story which you have of your client, and then apply the law. It can be law which comes out of a statute, or it can be a law on the basis of precedents which the courts have already decided on a particular point. So these are the two things that comes into your favor. But initially, you should have a strong factual basis. From there, you can build. So facts of the case are important. Very important. Right. And wherever you are, the lowest court in the hierarchy, or the highest court, which is Supreme Court of India. And with regards to the case laws and the precedents, they support the case as per se, or they take over in terms of the opinion of the judges? Opinion of the judges are always there. Right. Right. But you have to present your case in such a way that, as I told you, you build on the factual basis. And then when you are in the Supreme Court, you have to point it out where is the error committed by the High Court in interpreting either law or understanding the facts, which will help you in convincing the judge as to there is some error that is committed by the High Court which needs to be interfered. Only then the judge will be happy to entertain your case. See, what happens is, as far as the facts of the case are concerned, you can't argue afresh before the Supreme Court are trying to establish the factual basis of your case. As far as facts are concerned, the High Court is the final authority. When you come to Supreme Court, the way those facts are interpreted, the way the judgments of the court have been interpreted, or the way the statute has been thought of or interfered with by the High Court. So, depending on the nuances in these situations, that will help you in developing your case before the Supreme Court.
Just for kind of common sense understanding, practice in Supreme Court is mostly in what language?
Everything is English.
Everything is English. Right, from filing to arguing.
Everything. Even in the High Court is English, Supreme Court is English. In number of provinces across India, states as we call it, the local languages takes precedence.
In the High Court?
In the courts below
the lower courts. Okay.
Lower courts. It's only in English, both in the High Court as well as in Supreme Court.
And if anybody wants to do the local language, they cannot do it completely. It's just no, absolutely no.
It will be difficult unless and until the judge understands the same language.
Right.
If the judge understands the same language, he will try to entertain you. Or if there is some difficulty, the judge will appoint an amicus to assist a client in putting forth the case before the court. The court can appoint an amicus to assist them in pursuing the case of a client. If supposing a party in person stands before the Supreme Court and speaks, say, Hindi, because that's the only language he knows, then if the judge, one has to understand Hindi, assuming for a while he has some difficulty in understanding, even otherwise, the judge can choose to appoint an amicus, not only with regard to the language, but also with regard to interpreting the law. Assistance of a lawyer is always helpful to assist the court in coming to a correct conclusion. So, for that purpose, also, the court can appoint an amicus. The amicus can assist the court on behalf of the client to come to a correct conclusion as far as the case is concerned. Right. So, a lot of discussion with the judges to kind of adopt and Article 136 gives discretion. Right. The judges can also think in terms of, we agree with you. We agree also with the error that is committed by the High Court. We don't think it's a correct case for us to interfere with. Let us think of this in a better case. They can dismiss it. So the discretion gives them. They need not sit there to correct every error committed by the High Courts. Did you have a case where perhaps you were involved and then maybe the judges were kind of like not as forthcoming as you may have anticipated, especially like saying this way, like they were saying, go to the High Court. And did you kind of fought that case to convince them? There are a number of cases that happens. I mean, these circumstances come across a number of times. If I can tell you about one particular case which I remember, it has got a strange, it's more than a name, it is called 1486. 1486 were the number of employees involved in that case. And that's so more than the name, because normally the cost title is A versus B. Here also there was some cost title. But for us, it is easy to remember in the name of numbers, which is 48, because this was a public sector undertaking which was winding up. In the process of winding up, they were just sacking all these employees, saying that we can't provide any alternative employment route. So that was a very interesting case. And then the High Court did not favor the employees. That's so we landed in Supreme Court. I was fighting on behalf of the employees. Ultimately, the Supreme Court was convinced, not initially, but at a later stage. And the kind of order that Supreme Court passed, the order held in the employees for the state to assume its responsibility of accommodating all these employees in various departments of the state. So most of them, if not all, got absorbed in various departments of the state. Ultimately, we succeeded. But it was a huge task because the number was not small. As I told you, 1486. So ultimately, that helped.
How many years it took?
It took about maybe around 4 or 5 years. This case is maybe 20 years back. I think most of them were absorbed in various departments of the state. I think some of them have retired also. But the fact is, it was a huge fight. And it was not so easy before the Supreme Court. Ultimately, we succeeded.
So you developed your practice more as an employment related practitioner, or was it like various different legal areas you were looking?
Broadly speaking, I would say it is employment related matters. And in a very broader way, I would say administrative law. So more than being a criminal lawyer or a civil lawyer, it was lawyering in terms of employment and administrative law. So it was a major occupation as far as the profession in the Supreme Court is concerned.
Right. And where did you get the interest in cricket? Was it in Delhi or was it in Hyderabad?
See, interestingly, the cricket among lawyers started in Hyderabad. It started when I was there. But so after coming to Delhi, this particular all India competition among lawyers, as far as cricketing lawyers are concerned, was trying to expand. In the process of getting expanded, somebody approached as to why not you have a team from the Supreme Court to take part in the all India competition. So that's how the search began. And then we had a team from Supreme Court, and then slowly this expanded. As I told you, this cricket among the lawyers, that is All India Advocates Cricket Tournament. The name of the association initially was IACA, Indian Advocates Cricket Association, and we got it registered as CAAI, Cricket Association of Advocates in India. So that's the registered name goes. Otherwise, everybody is familiar with the name called ICA. ICA means IACA. So it started in Hyderabad in the year 1989. And because of some friends, I was introduced to this concept called All India Cricket Tournament among Lawyers, annual. And in the year 1995, I think, the Supreme Court team went to participate in the All India competition. And we started growing, started expanding. Today, there are at least 20 teams from across the country which takes part in this All India competition. It's an annual one. Not only that, there are so many All India competitions now, at least 3 or 4 of them, or maybe more than that. So what happens is, it is difficult for anybody to host a tournament with 20 teams. If it is 30 teams, if the entire country every high court bar has to come and then play under one umbrella, it's unmanageable. So this paved way for many All India tournaments. But the prime one is the one which I am speaking of. It was not only just All India tournament, and then we got to host this in the year 2002 in Delhi. When it was hosted in Delhi in 2002, that was the year when some people came forward and told me, we would like to make you the president because you have done a very good job. I told them, see, I don't play cricket. We just, few friends got together, we just organized it. This particular thought process paved way for me becoming president of this association in the year 2002, and I'm still there.
22 years now? Is that wow?
So, but interesting aspect is the connection of mine with this cricket activity started with one Justice L. Nageshwar Rao. Nageshwar Rao was a lawyer in Hyderabad, shifted to Delhi to practice law in Delhi in the year 1995. And it was he who came and told me, why not we have a Supreme Court team to take part in the All India competition? And that's how we started taking part in the All India competitions in 1996 onwards. So that's how I was introduced to cricket because of uh, L. Nageshwar, the senior advocate, subsequently. And subsequently, he became a directly elevated judge of the Supreme Court and retired thereafter. So it is because of his, what shall we say, scheme, encouraging, and all these things took place. But the interesting part is, when I became the president of this association in 2002, I started asking myself a question. I don't have anything to do inside the ground because I don't play cricket. I used to play when I was in college.
So bowling, batting?
But I used to bat a bit as an off spinner, all those things were there, but nothing much. But this was a competitive tournament, All India. Then I started thinking, I have got nothing to do inside the ground. What do I do sitting outside? There, I saw a phrase called cricket for friendship. When it began in the year 2002, I started thinking, uh, where this motor takes place? How do we do this? So there, the thought occurred, in the name of cricket for friendship, all of us lawyers are having an annual sojourn at some part of India. We have almost gone to all the parts of India, major parts of India annually. And this thought process took us, why not think of cricket for friendship beyond the borders? So in the year 2004, this particular thought process made us take a team of lawyers to Sri Lanka. We went to Sri Lanka by taking a team of lawyers from various parts of India as one team representing India, lawyers in India. We played 2 or 3 matches with our legal fraternity there. We had a good interaction with the bar. We went to the courts. All those things happened. But the important aspect is we carried with us a set of books called Framing of India's Constitution, which is a 6 set volume. Volume 1 to 5 was written by a person named Shivarao. And then the 6th volume was what happened since 1950 onwards. The author was Subhash Kashyap, who was the Secretary General of Rajya Sabha earlier. We presented this to the Sri Lankan Bar, which is called Bar Association of Sri Lanka, which is the representative body of the legal fraternity of Sri Lanka. We presented it to them. We had good pleasantries with exchanges, and then somebody introduced a trophy. Justice, the person named Suresh Chandra, who became a judge, retired, is no more. He is the person who introduced a trophy called Rajaratnam Trophy in the memory of his. He was a commentator. So that's how the interaction started. From there, we went to next year. It was an annual sojourn. We went to England in the year 2005. Went to West Indies in the year 2006. In the year 2007 and 8, we went to again Sri Lanka, Malaysia, Singapore. Over the period of 3 or 4 years, we went to all these places, build a relationship, as I told you, connect and build relationship with the lawyers here, especially with the lawyers who play cricket. But it was not just confined to the lawyers who play cricket. It is beyond that. These places, at every place, we carried a set of books framing for India's constitution. I'm telling you, in all these bars, you can still find this set of books. After more than a decade's gap, I went to Singapore and I was sitting in the Law Society of Singapore one day. And then, out of curiosity, I started searching in the library. And I found the set is there kept. And then that was interesting to see that in the bookshelf after a period of more than a decade. So interesting. The important aspect is wherever we go, to whichever country we go, we always used to invite them. Why don't you come to India? Understandably, because of our own passion, we did all that. We would expect the same thing from others. But what happened at some point in time? We said we will invite you together to come to India. I had a good interaction with the then Secretary of the Hyderabad Cricket Association, Mr. Shivraj Yadav, who was a test player, accomplished test off spinner. He gave me an assurance when I approached him with one of the founder members of this ICA, Mr. Surya Narayana. He said, Santhanam, don't think of any other place. You do your event in Hyderabad. I will give you all the facilities. That day, the search for where I can host an event came to an end. Then I wrote to every part of the cricket playing countries of the Commonwealth and invited them to Hyderabad. Come and play the first event. Thereafter, slowly and steadily, when everything, what you call it, developed where the event is going to happen, we named it called Lawyers Cricket World Cup. I virtually went to many of these places to invite them to come to India. By and large, it was successful. And I must say, how all this started, I don't know anybody outside India. But initially, as I told you, when we went to Sri Lanka, somebody gave us a connection of Mr. Suresh Chandra, who became a judge thereafter. And that's how we began. And where do we go next? So, in this, I must tell you, introduce the concept called Commonwealth. In the year 2005, in search of lawyers who play cricket, I came to attend this Commonwealth Law Conference in London in the year 2005. By the time we had made one trip to Sri Lanka, before attending this conference, I came to London. We brought a delegate of lawyers. At least 30 of them came to London during the months of
They were all from
June.
India or different countries?
All from India,
right,
as one team. We were about 30 in number. We were here from 1st of June till the 14th of June. With number of matches with mostly lawyers. And it was in that trip in England, I was introduced to a person by name James Cartwright, who was an English criminal barrister here. He was running something called a Devil's Cup, a one-day event, six-a-side tournament, starts in the morning and ends in the afternoon, late in the afternoon. So we took part. We took part in the year 2005, 6, and 7. So we lost once or lost twice, we won once, but it was an interesting thing. So that way, we got introduced to some of those who are based in London. But the most interesting aspect is connection across the Commonwealth of lawyers who are also interested in cricket. Otherwise, when I talk about Commonwealth or Commonwealth Lawyers Association, we are all concerned with rule of law. So, cricket and Commonwealth go together, and connections with lawyers across the Commonwealth was established in the year 2005 when I came to attend this conference. When I came to attend this conference in 2005 September, I brought out a publication There, a number of photographs, articles. From our experience in visiting Sri Lanka and in London was all there. And that was the booklet I could distribute to a number of lawyers who had got some inclination about cricket as conference. And that helped me in ultimately hosting the first ever Lawyers Cricket World Cup at Hyderabad. That time when we had this event in Hyderabad, uh, at some point in time, as an incentive, I wrote to all the teams which are going to come that day you land in Hyderabad till the day you take off, you will be my guests. So that also encouraged, helped me in getting 6 teams of lawyers. One was India, of course. We had a team from Australia, England, West Indies, Pakistan, and Sri Lanka. All of them came. And then I must say, we were successful in giving everybody free accommodation, free boarding, lodging, you can say, and also free cricket. Everything was free of cost for everybody. And that's how we began 2007-08. We began on 30th of December in 2007, ended it somewhere on 9th of January 2008. So it was a good tournament. How successful it was, we realized after 2 years. In a meeting of International Committee in Hyderabad, we discussed to understand and then find out the next host. And we were all successful collectively. We decided that cricket was born in England. So the event should come to England. There was resistance among the English barristers initially. Ultimately, they accepted that we will host it. And that's how in the year 2009, we went to Cambridge, played the entire tournament, start to finish, but the finals was in Oval. So that was interesting. As I told you, we took a call that we will have this annually, sorry, this event biannually. So since then, 2009, we came here to Cambridge. 2011, we went to West Indies, Barbados. 2013, we went to Delhi. 2015, we went to Brisbane, Australia. 17, we went to Sri Lanka. 2019, it was New Zealand, Hamilton and New Zealand. Thereafter, because of the COVID, there was a little gap, and then we could revive the event. And then we hosted the last cup in Sri Lanka. India hosted in Sri Lanka with the help of Sri Lankan lawyers. That was last December, January. And interestingly, we are sitting in London, and the next event is going to take place in England. And hopefully, it will be in Oxford. So that's how this Lawyers Cricket World Cup. It sounds like a great journey. It's from legal profession to legal lawyers, cricketing, and then Commonwealth. That's an incredible kind of journey. So how exactly do you manage yourself to kind of place into this Commonwealth legal fraternity world? Was it just the cricket or like more than that? I'll tell you, cricket took me to Commonwealth. Right. And Commonwealth took me to cricket. It is both ways. Both ways, okay. Right. In cricket, we are all concerned with rules. In Commonwealth, we are again concerned with rules and we say rule of law. Whether we like it or not, let us stick to the rules. Whether it's cricket or the Commonwealth. So it's an interesting interplay, but one cannot be alive without thinking in terms of rule of law. Because rule of law is an important foundation for a smooth running of every society across the world. And Commonwealth has a concept. The lawyers who believe that every society should run on the basis of rule of law, got together and run this something called the Commonwealth Lawyers Association. They have an biennial conference. I must tell you, although the association began in 2005, we got an opportunity to host this Commonwealth Law Conference in India in 2000. But I must tell you, although this conference is happening since 1955, where it was in a different name, this Commonwealth Law Conference is started in the year 19. I mean, conference as such started in the year 1955. It came to India in the year 1971, and Dr. L.M. Singhvi and then few others organized this in Delhi. For the second time, after my initiation into this organization, and after a secretary person by name Soli Sorabji, who was already part of this activity since the beginning, we could successfully host this conference in Hyderabad in the year 2011. By hosting it, not only their responsibility increased, but involvement in the Commonwealth Lawyers Association also multiplied. Thereafter, a situation came when somebody told me, could you not become the vice president of CLA? I said, why not? And that's how I became the vice president in the year 2015 when the conference was held in Glasgow. In 2017, I became its president. All this unanimous. It was a proposal accepted by all, and then that's all. But interesting aspect is the way in which very passionately I got involved in cricket. Similar was the passion when I started my journey as a Commonwealth Mission Commonwealth Connect. What I saw is, although it's a Commonwealth Law Conference happening biannually, what I observed was not many of the Commonwealth countries participating in it. Some people interested, voluntary come in, some people don't. So thereafter, I took it up as a Mission Commonwealth Connect. I physically went to almost all the Commonwealth countries, more than 50 Commonwealth countries. I physically visited, met the judges, met bar, the bar leaders, and then connected them with the Commonwealth Lawyers Association. The connection grew. The connection grew, and what you call it, the number of participating countries in the biennial Commonwealth Law Conference is about 40, 45 now. We will get delegates from so many of them today. Not only the activities increased, activities became multifold. The association works through various committees today, and it is like a live wire. The last Commonwealth Law Conference we got to host in Goa. It was in March 2023. It was a great conference. More than 500 delegates came and participated from across the Commonwealth. Normally, the number of delegates range from 500 to 1,000. And the next one is going to happen in Malta in April 2025, 6th to 10th of April 2025. I'll use this occasion to invite the legal fraternity from across the Commonwealth come and be with us, take part in in the conference in Malta next year.
So maybe if I could try and understand this. So you had all these kind of exchanges going on, conversation going on, interaction between the lawyers from like all across the Commonwealth. Were there any sort of learnings? Were there any kind of like findings or kind of maybe common consensus amongst them? to do something about the legal fraternity, or maybe that was not the mission, perhaps?
See, the interesting aspect is it is not just the connection.
Right.
Connection followed by building a relationship.
Right.
And ultimately for a common good.
So what is that common good?
The common good is when I say espousing the cause of rule of law.
And did you reach out any consensus on the rule of law so far yet?
There are number of situations where because of the, say, intervention, because of the voice that is raised in gut issues across in various jurisdictions, also led to some solutions here and there. For example, I'll tell you, when I was the president, I got to meet the Chief Justice of Kenya. His name was Justice David Maraga. The Chief Justice gave a judgment which went against the current then President of Kenya. Because of the judgment, he had to again contest for the elections because the earlier elections were set aside by judgment of the Superior Court of Kenya. Thereafter, what happened? There was a big hue and cry in a political level, calling out names, etc., etc. At that, the need was a moral support. What the judgment was about. It was in that situation. There are a number of international organizations which came in support of the judgment and to stand by what the judgment was about in Kenya in relation to what was the executive doing. I had an occasion to go to Kenya, meet the Chief Justice, and then tell him, our association is with you, as many other international associations. And ultimately, what happened? The interesting part is, although the politicians were calling names, the elections took place. It was a smooth affair, and the president got himself elected again. That's a different story. What I am trying to tell is this kind of international raising of voice and support was important for more number of judges in more number of jurisdictions to pronounce the judgment depending on demands of the situation, depend only to in support of or espousing the cause of rule of law. So there are a number of instances like this where CLA normally gives a statement in support or against something that is happening. So all those things builds international opinion that ultimately helps in various jurisdictions across the Commonwealth to not only uphold the rule of law, but in reality to speak out against any ills that is committed in various jurisdictions across the Commonwealth. And against the legal professionals or legal fraternity or anything else. That's the reason why we always speak in terms of independent legal profession, unaffected by what is happening across the political spectrum. Independence of judiciary, because these are important elements of the society which is useful in espousing the cause of rule of law. Do you have a guidance to offer to your members in that regard? There are a number of instances where we have charters or we have a, say for example, something called Commonwealth Charter. So a charter of rights and responsibilities of all segment of society as to what would happen across the Commonwealth. So when we make a statement, we try to rely on charters We also try to rely on what you call it, the various things that have come over a period of time in regard to the rule of law.
And over the years, I suppose the influence or maybe suggestions from CLA have become or taken more seriously by the world. You see that impression, like you gave the example of Kenya.
There are, I used Kenya as only one example.
Right.
There are a number of instances, especially the smaller jurisdictions, will definitely have what you call it, much importance to the world opinion. So there is an underlying fear if we go against the world opinion, if we go against the opinion of the people in that particular jurisdiction, that might affect their future. So these are some kind of a fear, right, which keeps everybody or forces everybody to think in terms of adhering to the rule of law,
which is quite important. I think it's a great work you guys are doing. And then you recently had a conference in London as well on Commonwealth and the Commonwealth Secretariat. Was it the Commonwealth Law Association or was it something else?
It was an initiation of the Commonwealth Lawyers Association that was concerning a field called mediation.
Right.
The importance for the field mediation is growing by the day, especially after the Singapore Convention, where more than 40 countries signed and ratified. Some of the countries ratified the Singapore Convention. The numbers have gone up to nearly 60 today. The importance is if there is a settlement between parties cross border, how we give legitimacy to that settlement. That comes because of the Singapore Convention. If X number of countries sign and ratify, what happens is any settlement between those countries, signatories, it attains legitimacy. Otherwise, you have to again go through the court process. With that, importance for mediation started growing. More especially with regard to the commerce. What is important is today we are in a globalized way as a world. You like it or not, we are in a globalized world where commercial transactions that take place between number of countries have to be given its due. When every country across the world signs and ratifies this convention, whatever settlement that takes place attains legitimacy then and there. Then you can ask a question, why mediation? Why not any other form of mediation? I was about to ask the distinction between various different alternative dispute resolutions and which one and why. As it happened, post-industrial revolution, this method of finding solution to the disputes, we started relying on the court system. Basically to find who is right and who is wrong. When the rocket explosion took place, it was not easy for all the courts across the world, especially the Commonwealth, to deal with the increasing workload. What they found is, why not have arbitration? So, in order to give legitimacy to this litigation, mode of dispute resolution, litigation outside the court system was arbitration. So, instead of going to the court, there are a number of disputes, especially arising out of a clause within the agreement. You refer to a private arbitration. To give legitimacy, we had this New York Convention in 1958. When we again saw, although the court system, we developed another system called arbitration, which is again settlement outside the court, by way of it's again an adjudication. Whatever happens inside the court, the same thing happens outside the court. So that by itself is not solving many problems. We still have a problem. So there the thinking started. Why not have another method? Instead of trying to find who is right and who is wrong, why not think in terms of trying to find what is the interest of the party, the disputant parties? That gave rise to, paved way for this method called mediation, where the role played by the mediator is not to find who is right and who is wrong, but try and drive the parties towards what is their interest. The method of negotiation, it's a scientific process. One has to train to attain this particular skill, to find out as to what is the interest of the parties and how can parties overcome their ego and then drive them towards what is their interest. So it's a different method, a scientific method, where we end up in a win-win situation. The most important aspect of mediation is ultimately when the matter is settled, the relationship between the parties, disputant parties, remains. Whereas in the adjudicator system, either through court or through an arbitration, A wins and B loses. The cause of B continues even after the dispute comes to an end. Whereas in mediation, it's a win-win situation for both the parties. The relationship is kept intact, and there's a possibility of the future relationship building again. So that's the reason why we say, let us now concentrate on the interest of the party, from deviating from so far which has happened historically, finding as to who is right and who is wrong. So slowly this particular field called mediation is catching up. And coming back to the question which you posed, the Commonwealth Lawyers Association as a delegation led by the president, Dr. Peter Maynard, it was his initiative that took us to the Commonwealth Secretariat. We met the Secretary General, Patricia Scotland. We met the Assistant Secretary General, Professor Louis Franceschi, the heads of Department of Rule of Law, Dr. Elizabeth Vicaria, and then few others. The interaction there was with regard to, we were about 6 or 7 persons from CLA representing, mostly based in London. I came from India. Dr. Peter Maynard, who was the president, came from Bahamas. We were about, it was on 9th of May. And it was my turn representing the ADR committee of the CLA. I'm the co-convener of this committee. I said, we are all trying our best in various ways to promote mediation as an ADR method. But I feel this is not enough. From a promotion mode, we have to put this into a mission mode. Putting this into a mission mode is possible when you support us. This particular statement probably gave Philip to an idea. The discussion, the thought process ultimately took us to an event on 21st of June, a week back. This was basically a mediation awareness event where we, number one, launched the mediation training program which CLA is going to undertake, formally declare it in the month of September, and then few months thereafter we'll start doing the training. The awareness event was basically not only about launching this training event, but also we shared with everybody what we are going to do in the coming months. In July and August, we are going to have a summer school on mediation. This will be the 5th year in which we are doing it. When I say we, I am the president of an association called Nivaran. Nivaran is a Hindi word, uh, meaning thereby complete solution. These are a collection of mediators from the Supreme Court of India. We have been running this activity since 2019. And then we gave ourselves a name called Nivaran. We had registered ourselves as an association. President. We have been doing many activities to promote mediation. And one of the important activities is uh, International Summer School on Mediation. This is supported by the Commonwealth Lawyers Association on the one hand, and on the other, it is supported by the Singapore International Mediation Center. With the support of these two major organizations, we run this school, and this year it's going to be the 5th year. Hopefully, from 26th of July, with the opening ceremony being uh, being there on 26th of July, as I said, by the Supreme Court, the Chief Justice of Supreme Court of India, the Chief Justice of India, I should say, we would start this event, and this will go on till 6th of August. We will have a formal opening ceremony, a formal closing ceremony, in between 10 days of lectures by experts in mediation across the world, mainly Commonwealth. We will start from the genesis of mediation to mediation advocacy and beyond. Various topics concerning mediation. The concentration is to promote mediation across the Commonwealth. So this is actively supported by CLA. As I told you, we said in July and August we will have this. In September, as I told you, we will launch the mediation training program. In October, hopefully, we will take part in the Chogam, where we have something called peace mediation. The kind of world in which we are living today, it is full of strife. Why not promote this idea called peace mediation? So we are planning to host an event during Chogam in October, which is going to take place in Samoa. Thereafter, in November, we are planning to host a Commonwealth Med-Art Conference in Hyderabad on 22nd, 23rd, and 24th of November. Besides all this, from the month of September onwards, we have guest lectures of at least 5-6 guests who have signed, give presentations on behalf of CLA on various topics of interest in mediation. So that will also start somewhere in this. And all these things ultimately will lead to flagship event of the Commonwealth Lawyers, which is called Commonwealth Law Conference in Malta from 6th to 10th of April 2025. So in the event that happened in the Commonwealth Secretariat, Marlborough House, on 21st was a launch of all this, and that's why we called it Mediation Awareness Event. And the most important thing I must tell you, which impressed many people, was we had more than 1,000 registrants participating in this event. Hopefully, around half of them attended. We had a physical presence of more than 60%. We missed you on that day. So, the interesting aspect is from the feedback which I got, I'll share with you that everybody, by and large, liked this, the way in which it happened. The curiosity was with regard to when are you going to start this mediation training? We would like to come and participate. What we presented was that as opposed to normally the way the training happens is the 6 day, 5 days, 40 hours. What we thought was, why not we spread this, say about 8-9 weeks, each time when the training course starts, we spend about 3 hours into 8 or 9 weeks. So whereby not only sharing of just teaching of lessons, but also lectures on important aspects of mediation, play, homework, etc., etc. All these things will be rolled into one capsule called Commonwealth Lawyers Association Mediation Training.
You have a full plan and a kind of great calendar up until 2025 on mediation. There is another term, and I'm not trying to jump from the topic. I think the mediation is a great avenue to solve, especially the business or the any kind of dispute which they emerge to. But reconciliation is also one of the ADRs, or is that in the focus nowadays, or not at all?
See, reconciliation is where we suggest solution to the parties.
Right.
In mediation, we don't suggest any solution. We drive the parties towards solution. What we say is, what is the solution? It is the parties which decide.
Right.
We don't decide as a mediator. Right? We drive them towards solution. Drive them to think in terms of what is their interests. So that's the reason why conciliation, although is used in India, we have an act called Arbitration and Conciliation Act 1996. It was amended a few times next time thereafter. But the concept of conciliation came because why not? Why just arbitration? Why not conciliation? Which means you give suggestions for the party to agree. All these things were there before mediation as a concept developed. And thereafter emerged this concept called mediation, where why should you suggest solutions? So
anybody looking for mediators should go to CLA or to the Commonwealth. Where can they find mediators? Where can you find, or anybody
there are so many organizations across the Commonwealth and beyond,
right,
who are espousing the cause of mediation. There are so many, what you call it, bodies, which not only conducts mediation training, but also have platforms to entertain and do the mediation. I must also tell you that recently there was an enactment in India which is called the Indian Mediation Act 2023. This act contemplates that a mediation council of India will be appointed, will in turn give us two important things. One, to recognize the platforms which do mediation training, and also recognize the bodies which are going to conduct mediations. So far it was an informal thing. The things that were happening was court annexed mediations, and the training was conducted by the MCPC of the Supreme Court of India, which was Mediation and Conciliation Project Committee. Today, with this enactment, the horizon is broadened, whereby number of people who are involved in mediation, either training or doing mediations, will be formalized under one called Mediation Council of India.
And Mediation Council of India would be governed by Ministry of Justice in India, or
correct?
Okay, so it will be under the government's own umbrella. I think that sounds like a sensible way to look at it in the future. But then I think so. The mediation, arbitration, conciliation, or any other ADR, is there any cost effectiveness element to it?
It's very cost effective.
Right.
Not only cost effective, but also time effective. In the sense, normally what they say is, if you one step into the court system, by way of, say, initially filing a suit for whatever the reasons, it can be declaratory suit, it can be suit by recovery, whatever. It takes 20 years' time. This mediation, if everything goes well, within couple of sittings, within 3 or 4 sittings, within 4 or 5 sittings, everything is settled. And all these things happen within months. It doesn't go years.
Give an example of a recent mediation, perhaps. Did you do any recently?
Yes, I was a co-mediator in a case where there was a dispute between say, husband and wife and concerning the property. We got it settled in about, I think, 3 or 4 sittings. Started and ended within months. 3 months, I think.
So when you say co-mediator, I mean, so you can have single mediator, co-mediator.
See, wisdom need not be confined to one person. Right? If 2 mediators sit, deal with the mediation, they can talk to each other. So one person might come out with a better idea. Right? So it helps the cause. So that's the purpose of mediation. I've done number of work as co-mediator. It's sitting with somebody else. So it's an interesting experience. What happens is you might not correct idea in that particular situation when you're totally involved. A person who is passively sitting and observing might have something to say with you, to you. So it helps the cause ultimately.
Right. I think sounds like a good kind of way to resolve the issue and more cost effective than perhaps people should look at it. And then they can get more information on like just doing it.
As I told you, it's not only cost effective, it is also time effective.
Of course, yes. Yeah, time effectiveness as well. And so beyond, let's say, ADR, alternative dispute resolution, do you have any other activities which is ongoing? Because I can see you've got legal, cricket, Commonwealth Lawyers Association, and the alternate dispute resolution as well. Yes. I mean, is there any focus about the legal fraternity as such? I mean, is there something which is kind of more focusing on the lawyers' well-being? This quite hot topic these days where I'm coming from. Also, the kind of environment of the facilities they have in the Commonwealth. Is that on your radar?
See, burning out is always an important aspect. So we are also equally concerned with lawyers' well-being. So as part of our Commonwealth Law Conference, we also have a topic where experts come and share with us,
right,
as to what are the various methods through which you try to deal with the burning out problem, right? So where the lawyer's well-being, in that sense of the term, is taken care of, which is very important because you don't realize when you're seriously involved in your client's case, you work, you work. So with the result, instead of helping the client, you need somebody else to help you in overcoming certain difficulties. So lawyers' well-being is always an important agenda. We always have a topic on that to discuss at the Commonwealth Law Conference.
Incredible. That's good. Sir, I think I've covered mostly whatever I wanted to discuss on today's topic. I think that's really great that you are doing remarkable work with all these different kind of pursuits of your being as a person and a lawyer and a cricket amongst the lawyer and the Commonwealth Law Association. I really appreciate your time. Thank you really so much for talking to me. And I hope we'll continue this conversation maybe on the next round with maybe more different topic or maybe during the Malta conference.
Thank you so much, Praveen. Thank you very much.